I'm here today with Bill Finkelstein, who is the former president of the International Trademark Association, as well as the former vice president of intellectual property for Pepsi Brands for 27 years, and currently a partner with the law firm of Steptoe and Johnson in Century City. Hi, Bill.
Hi, Cheryl.
Bill and I go back a ways as friends, and we have some common interests in obviously brands and brand protection and trademarks. And you were gracious enough to get together to chat about a few things today.
Sure.
And we wanted to just talk a little bit about what makes for a good trademark and some of the issues that confront business owners. Bill, what makes for a good trademark?
Well, the most important thing certainly is for it to be memorable. You want people to remember it when they go to the store, when they go online to make purchases. You also want it to be a distinctive trademark, which helps with memorability, so that when you advertise it and when it appears on packaging, people immediately recognize it. A lot of people choose their own names, and of course, if you choose Bill as a trademark, how many thousands of Bills are there out there, or Cheryls or whatnot, or even last names. Even take something like McDonald's, which right now we would say is a distinctive trademark, but many years ago, choosing your last name, and there are other McDonald's out there, it takes a long time to build an investment and to spend money and time and advertise to get that recognition factor for something like a surname or a geographic name. Now, not every trademark has to be a made-up name like Pepsi, those are really good trademarks.
So Pepsi's actually a made-up name. Where did it come from, by the way? Do you have any idea?
The illusion apparently back in the 1800s, the late 1800s, was to calming your stomach down. And, peptic, a Latin word having something to do with your stomach. So I think that's the best guess that anyone has, because in those days, soft drinks were actually dispensed at soda fountains, which were inside drugstores. So that is apparently where it came from. But basically, it's a made-up word. It's not in the dictionary. And therefore, it's what we call a very strong trademark. Because when you see Pepsi or you hear the word Pepsi, it only conjures up one thought. When you have a trademark like Apple, if you just use the word apple, it could refer to, obviously, the red thing that we eat.
Yeah.
And at one point, and of course, it also refers to music and record albums. As well as, obviously now, the very popular computer. But again, with a dictionary word, it's a little extra investment, a little extra time to develop the kind of association between that word and the product or service that you're selling.
So when you say a dictionary word, you mean like an ordinary word, like an apple, because it has a meaning or generic term, we'd like to say sometime. It's generic for a fruit, a kind of fruit. But it can be a good trademark if it's applied arbitrarily to something unrelated to fruit.
No, exactly. And so Apple can be a good trademark for motor oil or perfume or computers.
Well, the Beatles
obviously
were the first to use it, I know, in music.
Right, on music. And
record label.
And of course, I don't know if you know this story, but they originally made a deal with the Apple computer people at the beginning where Apple was not going to be in music. Apple Computers was not going to be in music.
Exactly.
And they never envisioned, they were making computers. They never envisioned there would be a technological crossover into the music business, which we now know as iTunes.
Isn't it true that the Beatles actually opposed or tried to stop Apple from registering it at some point in the proceedings, I think because they were registering it in the same class for computers, and Beatles opposed it and said, we don't want you using it in the same class where music, because they had for sound recordings.
Right. I think that's exactly right. And I think my understanding is they came to some sort of arrangement, most likely with some extravagant financial terms, which are confidential. But the difficult part sometimes with trademarks is as things develop, as a business develops, it could take many different forms, and especially as we know, as technology develops and as quickly as it's developing, trying to be foresighted and trying to come up with a trademark that isn't too descriptive. Because if a trademark merely describes something, a product or a service, then it also is not eligible to be a trademark, absent a tremendous amount of advertising, marketing, and sales over a number of years. And still, other people can still use the dictionary word for its descriptive meaning, such as selling apples for apples. The Apple computer and the Apple Music people can never stop that. So choosing a trademark is very important, and you try to choose the most distinctive one that you can.
Well, I mean, having been at a company like Pepsi for 27 years, you had the advantage of working with a brand that was established, that already had a real reputation, and as you said, it's distinctive and strong. But, you know, in private practice and you're counseling clients, have you seen a tendency or challenge for clients to understand that distinction? At least in my case, I tend to have people who come in and they come in with what they believe is a great name, but it tends to describe what they're doing.
Right, and it's a natural tendency because they want to take the fastest route they can to get consumer recognition by telling people, you know, easy off oven cleaner. They want people to understand that's an attribute of the oven cleaner. The problem is you can't stop all your competitors from saying our XYZ product makes it easier, or we can take off dirt, use the word off, faster, etc. So, you know, the good news and bad news is it gives you an immediate entry into the marketplace. If you called your oven cleaner Pepsi, you've got a lot more education and marketing to tell the consumer what it means. But once you do, then you've got a very strong trademark and can protect it against others. Whereas if you go with the easier route, which, as you said, a lot of our clients want to do, that presents problems, and that's a pull and tug between trademark lawyers and business people generally. All business people, they get it, they really get it, but they still, their tendency is, their default is to go to something, you know, highly descriptive, or just, if I misspell a K and a C, is that good enough? You know, and of course, if it's still a descriptive word or a generic word, worse, then it certainly, you know, is a problem.
My advice sometimes is to say to people, well, why don't you save for those laudatory descriptive terms for some good tagline that explains what it is and have the mark be distinctive? Because one of the things that I've seen looking back over, you know, my practice is clients end up with trademarks. They may ultimately be able to somehow get it registered in some limited form, either with a logo or whatever, but then when they have to sue someone is when the problem is. Because what they don't understand is that they have to prove and have how should we say it, a higher burden of proof. They have a higher burden of proof in court to prove that before a court's going to enforce that as a trademark.
Right, and you have to show that there really is consumer recognition, and some of the ways in a litigation might be, for example, taking a survey, but those things are very, very expensive. And so it's a combination of being short-sighted and far-sighted. And oftentimes companies can have an entire life of a product and never have litigation, and sometimes they can get away with it and have the opportunity to build up what we call the secondary meaning, the development of consumer recognition and distinctiveness over time. But sometimes you don't have the luxury because something is a new and a hot term in a hot field, and everybody wants to jump on it all at once. And there's some examples you and I were talking about recently. If you want to get into those, we can do that.
Yeah, we were talking about that. How
exactly.
There's these terms that sort of become ubiquitous in society overnight.
Sure. Well, Boston Strong, unfortunately, is an example. I say unfortunately because it led directly from the terrible tragedy at the Boston Marathon this past April. But immediately thereafter, as a rallying point within the Boston community, everyone started using the phrase Boston Strong, and it appeared at sporting events and at other public events, and signs were going up all over town. And at the same time, being the entrepreneurial nation of capitalists that the United States is, that we are, people all of a sudden started wanting to get trademark rights, and people were filing trademark applications
for Boston Strong,
on T-shirts and mugs and posters and that sort of thing. Unfortunately, trying to capitalize on obviously a terrible event. And the question is it too late? Sometimes the barn door can open so quickly, and there's so much ubiquity to the use of a phrase. No one person either could or should, and some people would say should in this instance, be able to take advantage of what's now in the public domain almost overnight. I mean, that rarely happens, but it certainly happens. I remember back in the 90s, back in the last century, when we invaded Iraq, the name of the operation, the military name, was Shock and Awe.
Right, Shock
there were, within 2 weeks, there were dozens of trademark applications filed for Shock and Awe, for video games, and obviously T-shirts and the usual sorts of things, and posters, and all sorts of, and toy guns, and et cetera. And they all had to be sorted out. But those were actually legitimate, could be the first one in, and we can talk about this later, how you get trademark rights. That probably is a legitimate trademark because it generally wouldn't describe if it's a clothing label, for example, or possibly a video game. It might be a little descriptive, but it's just a question of these I call bandwagon situations, where some public event happens, and the next thing you know, everybody and his brother is trying to claim trademark rights, because trademark rights generally go to the first user or first applicant. So there often can be a race.
Yeah, we were discussing earlier about an interesting one in the entertainment field relating to the name of Beyonce's baby.
Yeah.
What was it?
It was Blue Ivy.
Blue Ivy.
And when they announced the name of the baby, Blue Ivy Carter, I guess is Jay-Z's actual last name. Several entrepreneurial people filed trademark applications for Blue Ivy for a whole variety of things. And then Jay-Z and Beyonce formed a company, and I think the baby was born on January 7th, 2012. They didn't file their application until January 26th. They were busy. They had a few things to do. How to get the baby home and decorate the room and do all sorts of things and stay up all night, etc. They weren't focused on it. And then about 3 weeks later, at some point, they realized they better file a trademark application. In between, at least 2 other people had filed trademark applications for Blue Ivy for a whole variety of clothing and baby goods and et cetera, et cetera. And one of the excuses one of these people gave was, well, I was going to pitch Jay-Z. I have a friend of a friend of a friend who knows Jay-Z, and I wanted to get the rights on file to protect him, which of course.
We've all heard that story, especially to do with domain names, you know.
I was just doing it for you, you know. So luckily the trademark office took the early on position that because these applications would be a false association with a famous person, namely Blue Ivy Carter, that they immediately bounced those 2 applications, even though they were filed prior to the Beyonce Jay-Z application.
That's fairly unusual.
Yeah, it is unusual. It is somewhat unusual. Usually first in time has priority, but in this instance, it was so obvious, the office took this false association position right away and knocked them out. The flip side of it, and getting back to our discussion about the use of ordinary dictionary words, now, obviously they named their kid Blue Ivy for personal reasons, if you will, but there were 2 or 3 other people already in businesses in this country with the name Blue Ivy. Who had filed and started using years ago, a retail store in Wisconsin, and a woman who I believe was in Connecticut with a event planning business, wedding planning and whatnot. They both thought Blue Ivy was a nice name for their businesses.
Maybe she can plan the wedding in years.
So then the situation is now these people have prior rights in those categories, and they theoretically, even though Jay-Z and Beyonce had no intention to rip them off in any way, and their adoption of Blue Ivy as their baby's name was just completely coincidental and personal, they theoretically now have a problem because they don't have priority. The wedding planner and the retail store have priority over them in those categories. And that's something to talk about too. I mean, you know this.
Well, you raise a very interesting point, I think, because another common misperception or point of education for clients when they decide they're going to protect a brand name is to understand that they can't necessarily protect it in all classifications for all goods or categories. Obviously, there's an exception when something becomes famous. I would say Pepsi probably falls into that category.
I would hope so.
That Pepsi, and what I mean by that is that Pepsi would be able to stop someone from using Pepsi for almost anything.
Sure. I would like to think even perfume or automobile tires or whatever, even if it's not part of the core of our business, because it's such a unique, distinctive, non-dictionary word, it would give us the ability to police it in all categories. But something like Blue Ivy can exist in lots of different categories.
And that's typically true for someone starting out in business because they don't have as much consumer recognition as someone like a Pepsi. So, of course, they're limited at the beginning to where they're using it.
Sure. And also that when you file trademark applications, and we have a lot of clients who come in who say, I want to file in all these categories, and putting aside the expense of that, you know, they have to sign a piece of paper that says they have a real bona fide intent to use in perfume and automobile tires and computers and all these disparate businesses of which, you know, they have no interest, no technical skills, no anything, and no basis. And that application can be invalidated later on because you have to have some ability to translate your desire to trademark something into an actual business. And so that there's a somewhat of a tension there. On the other hand, as you know, usually money controls. It costs so much money to file in so many classes. There's a natural breaking effect, and people just focus on.
Yeah,
the
once they
business in
find
front
out
of
it's
them.
not just at legal fees, it's the filing costs for the government.
Right, exactly.
For each category.
It sort of acts as a deterrent to their wishing to file in every category known to man.
We were talking about one other one, which I really love this example. It goes back in history to World War II with Winston Churchill.
Right. No, exactly. Apparently, back in the days when England was really in fear of being invaded by Nazi Germany, and I remember visiting the War Museum in London, and they had posters there of what to do if the Nazis invade. And another poster was a notice to the farmers: kill all your cows.
Really?
When the invasion happens, so that the Nazi army could not feed itself.
Mm-hmm.
Now, I'm not sure how the populace was supposed to eat, but somewhere along the line, this was a real time of fear. And there were other posters, morale building posters out there, and one of them was this one that's
you brought
become
with you.
yeah, I brought with. I know we can see it here. Has become very ubiquitous now.
Keep calm and
Keep
carry
calm
on.
and carry on. And it just even sounds very British.
Yes, doesn't it?
Carry on, right? And there was a whole series of Carry On movies years ago. I don't know if you remember that, but your grandparents
I actually think I could use a copy of that from day to day.
But a book. The long story short, a bookstore owner in the UK found a bunch of these posters. And in a storeroom somewhere, he dealt in old books. Maybe he picked them up in an estate sale or whatnot. And he he put them out. He maybe found 20 of them, and they started selling like crazy. So he decided this could be a nice little side business, and he went to the Kinkos of the UK, and he replicated them and started selling posters, and was selling a nice little business selling posters. And then someone else, it started to catch on, and another enterprising entrepreneur, a UK entrepreneur, so capitalism isn't confined to the United States, went out and decided to go into an entire licensing business and filed trademark applications in the European community, which covers the UK and the United States and other countries, for a whole wide variety of the classes we just talked about. All the classic mugs and trinkets and jewelry, posters, stationery, stickers, you name it. And indeed, you can see them all over now. And the question is, was he going to go after this poor little bookseller who started the whole thing? And he indicated he was not. Even though he had filed first, the bookseller never even thought about filing for trademark protection.
Too bad.
Yeah, no, exactly. And this is another issue that we certainly can talk about.
Well, what many
using
people don't
versus
realize,
filing. Yeah.
and we'll get into
Yeah.
that, but in the United States, what people don't realize is in other parts of the world, you don't have to use a mark before you file it.
Right.
Or to keep a registration at least. You can actually register it all the way to registration without having used the mark in
Right.
Europe.
No,
So
exactly.
it's first to file, and
Yeah.
and that's I think what you're referring to.
Yeah, no, so this fellow jumped in and filed first, and there was such a public outcry. Twofold. Number one, was he going to go after this poor little bookseller who was eking out a living selling posters and who had discovered it in his basement? And number two, wait a minute, this should be the property of the British people. What is this guy doing? This is something that should be in the public domain. And he is proceeding with his business, but there has been a backlash apparently against him because of this sort of public domain argument that this is a phrase that all of we British people should have. But now the other interesting part is, in terms of this fellow's business, is it has now been copied incredibly in a whole variety of different ways. So, for example, I'm just going to read you a quick list of something I went on and found. Keep calm, drink tequila. Keep calm and carry out. I guess for a carry out food business. Keep calm and let me fix your hair. Keep calm and have a cocktail. Keep calm and keep shopping. So
I like that one.
I like keep calm and have a cocktail. So so now he's sort of lived by the sword, died by the sword. Again, he adopted a phrase with very common words in it. And
so he's got an uphill battle if he wants to maintain it, because technically he's supposed to go out and police his mark.
Right.
And that's going to be quite expensive to go after all those people.
No, exactly. And also he's got this other public perception problem, that he's taken something that belongs to the British people. And this was their rallying cry in World War II or whatever it might have been. So he's got a moral ground to defend as well. So it's still unfolding. This is happening, but as we sit here, but it's just, again, it's evidence of this bandwagon effect, that something catches on and everybody wants to capitalize on it. And so it's so important to, if you do think of something, even if it's not one of these bandwagon things, if you just think of something on your own, for your own business, to try to perfect your trademark rights as soon as possible. So I don't know if you want to get into that at this point.
Yeah, no, we also were going to jump into the conversation about how does one actually acquire rights.
Right.
We talked a little bit about Europe or the rest of the world where use is not required to register.
Mm-hmm.
The United States traditionally had that rule up until a number of years ago. So now we have a two-step way of acquiring rights. One is based on I intend to use it, and the second is I've already actually used it, which can be a little confusing for clients at the beginning.
Sure. Well, the idea was that the idea of changing to a bifurcated system where it gives you the option of intent to use is what would happen is, let's say you're going to build a hotel. That could take 3 years. Or you want to launch a new drug product. Well, you've got to get FDA approvals. And if you only could file after you've used, someone else, especially if it's a dictionary term or something other, or it's a surname or a geographic name, someone coincidentally could file.
And that happens all the time.
And it does happen all the time. And so we had to come up with a way to protect people while they were in the development stage, and came up with this intent to use system so that if you have a bona fide intent to use, you can file a trademark application and basically have 3 to 4 years to develop your product, test market it, get it out there, etc. And then once you use, then you can perfect your registration in the United States. So eventually you're going to have to use it to protect it. But this gives everybody the ability, as soon as they think of something, and indeed, like I said before, they have a legitimate connection, that they really have this is the business they're in or they're about to be in. There have been situations where people have filed applications and just because they thought it was a really cool thing to do, and they just sat on it and never developed a business, never had that kind of expertise, never did a thing, and those applications were taken away from them.
Yeah, because at some point in the United States, you do have to step up to the plate and prove that you're selling the goods in commerce.
Right. No, exactly.
And that raises an interesting question because we've seen this, and I know I've been involved in a case recently with a situation where sometimes people don't register at all, or they wait a long time to register.
Right.
And that can get into an issue of what's called territorial rights. And because in the United States, one can still acquire some rights without registering, which is seems like it's a little bit contradictory, but that's the law.
I mean, in this country, we've come from a tradition of, if you will, small shopkeepers, small farmers, as Jefferson would say, where we don't want to force every single person in a small localized business. My local dry cleaner who has a business area of 10 square blocks, to force her to file an application in Washington, even though the fees aren't that great, you still have to hire expensive lawyers like yourself, and it's just not necessary because and so what the law allows is my dry cleaner to have territorial rights. So for 10 blocks, basically no one else can name their dry cleaner the same name as hers. And talk about terrible trademarks, by the way. I don't want to pick on my dry cleaner, but the name of her dry cleaning is Express Dry Cleaning. So that is about the worst trademark I could think of because, as we said before, it's very descriptive. But assuming she had a good trademark for her dry cleaner, it would only extend to the area of her use and reputation. So as far as she had customers and people came from 10 blocks or 20 blocks, that would define her zone of trademark rights. And we see this very often in the restaurant business. I've done a lot of trademark work in the restaurant area, as you have. And we see this often where people have a small restaurant and they don't think about it. I mean, they give it a name, and maybe they'll get a state registration in the state of California or a DBA in Los Angeles County, which again gives them very, very limited rights. And they don't. But unfortunately, most of the time, it's not an arbitrary name like a Pepsi or Xerox or any of those made-up kind of names. They're more common names, or somebody's last name, surname, and they'll just be going, tripping along their own way in their own little business for many, many years. And then unbeknownst to them, someone in Tennessee or in Maine or in someplace else came across the exact same name. Maybe it's their surname as well. And the next thing you know, they start their own restaurant business. Well, as long as the two of them, one stays in Maine and one stays in California, there's no problem.
Yeah, they're never going to run into each
Right.
other.
Although the internet, and we should talk about this, has created
A potential for a real
potential
shift in
overlap that
yeah.
never happened before. But generally, those two can coexist. But what happens when the one in Maine decides to franchise or
Around the United
expand,
States.
and the next thing you know, they're in the Midwest, and the next thing you know, they're in Arizona or Nevada, they're in Vegas, where you have a lot of people going back and forth between California and Vegas. And then you have this potential for running into each other. The only solution really in terms of each of them is someone should have being the operative word, filed first for a federal trademark registration. Because when you file, you get your claim on file, you've got your rights from the date you file, and it establishes that beachhead we talked about to give you time to develop, whether it's developing the business or the product or developing a larger geographic breadth. And to a certain extent, if you file first. But the caveat to remember there is even when you file, let's say you file on January 1, 2013, for restaurant services, any other restaurant in this country that's been in business up to that date will always be able to use their name in their locality and have that protected zone of use and reputation, whatever it may be. So even filing the application doesn't cut off the prior users, it just cuts off anybody subsequent. Right, which is still very, very helpful, obviously, because there could be somebody in Michigan who all of a sudden comes up with the same name and starts. There are only so many ways to names for hot dog places or hamburger places.
Well, I mean, I was sharing with you a client situation where one came up, and it's not quite as commonplace, but it still turned into an issue because of territorial rights. And then you mentioned earlier the issue of the internet, because one example that came to mind for me is, I happened to have purchased a camera from a New York camera store where they ship, or I don't know, I recently purchased something from Alltrek in Oregon, which is a fabulous outdoor store. Mm-hmm. They're not a nationwide chain. They're not in multiple states from a physical location, but they have a huge internet presence. They ship all over the United States. They have a website that's very interactive. They have shopping carts. It's really as big as looking at something like a Barney's or a Saks Fifth Avenue online. They have thousands of pieces of merchandise. So almost every item that's in the physical store is in the online store, or a good portion of it. So that raises the question of what are their territorial rights,
right.
And what impact does distribution of products over the internet have for purposes of establishing trademark rights.
Yeah. It's a very difficult issue, and actually, interestingly enough, considering how long, if you will, the internet's been around now, 10, 15 years at least, with a lot of sales, maybe a little bit more, there's not been any crystal clear resolution of this in the courts. The courts have danced around the issue, looked at the specifics of the situation, but the Three Palms case we were talking about,
that's a very recent case.
Yeah, and the court, I'm not sure I actually agree with the decision. The court disregarded the fact, this is hotels, that hotels are booked by people nationwide on national sites like TripAdvisor and Expedia. Expedia will list all the hotels right next to each other. If you say, I want to go to a hotel in Scottsdale, Arizona, it'll give you all the Scottsdale hotels. I don't know if it is rightfully decided. I mean, you want to talk about the facts, or I can fill people in?
It was an interesting fact pattern because it goes back to an example of what we were just discussing, which is we had a senior user, the first to adopt and use the mark Three Palms in Scottsdale, correct, for hotel.
Right.
And he didn't register right away. I don't think
he's ever tried.
He never filed.
He might have finally filed when this whole thing
started,
after the controversy
And I think it was
started.
Maybe from 2002, I don't know, fairly recently in the history of things. And then about 4 years later, there were some folks in Florida who adopted and started using, and they also started licensing the name and franchising. But interestingly enough, they still were only in 6 states. It wasn't as if they'd gone nationwide.
Right.
They were only in 6 states as of the date.
One of them being California, which is fairly close to Arizona, I guess. But to me, people book hotels online a lot now, mostly. And it's not if you see in the old days you saw an ad in the paper, your friend told you, oh, there's a great hotel. I'm going to Scottsdale. Where should I go? Oh, there's a great hotel called the Three Palms, and you looked it up in the phone book or whatever.
So now you type it into Google search.
Exactly. It's completely different now. You don't go to someplace because somebody told you about it, you saw an ad about it, or it's in the phone book. I mean, you look online in Google, Expedia, TripAdvisor, and you're going to see Three Palms, and you're going to see the other Three Palms hotels in these other 6 states, and you might think they're connected. And I think the average person could easily think they're connected. The decision didn't say anything about whether one was, a very fancy, expensive hotel versus a little motel. I mean, that might be a distinction, but I didn't see anything in there about that. It was a registration decision. That's probably
and also just to clarify, this was not a case where they were actually necessarily suing each other for stealing the name. They were suing for what's called the concurrent use registration, which is the right to divide up the United States.
Right.
And who got what states?
Yeah, well, the late coming Florida people wanted the entire United States
and they got
except
49
for Arizona.
states, and they won.
And the Arizona guy said, "Wait a minute, I have people coming from all over the country to my hotel." And maybe the problem was that some of his testimony wasn't credible. I mean, that often, is the end result of these cases is based on credibility. He seemed to have this sort of thing about, I've been thinking about going out, and I've made all these bids to buy other hotels, and the tribunal didn't really
seem to buy it.
They didn't buy it. They really didn't, and I think that hurt him somewhat. But I don't know. I mean, I still think in that particular milieu of hotels, which people come to nationally. Restaurants, you don't necessarily go someplace to eat in a restaurant.
Well, what about a physical product? I mean, in the case I was discussing with you.
Products are tougher.
Let's say wine,
sure.
I mean, you don't have, it's something that's distributed physically. It's not a service, as opposed to like going to a restaurant.
Well, I mean, if you can get something on Amazon, you can get it in every state, even though you may just make your products in one state. I mean, the internet allows you to sell to all people in all 50 states, let alone internationally.
Well, and I think that's what's interesting to me about this Three Palms case is the fact that they were talking about what they call the virgin territory.
Right.
In other words, there's the territory where the first user was in Scottsdale, the state of Arizona. Then there was the 6 states in which the junior user came into. But then it raised the question, who had the right, or did the second company have the right to continue expansion and also lay claim to the rest of the United States despite there was a senior user? And that was really the bit of an interesting part of the decision, because they actually used language saying that the senior person, because he hadn't really made sincere efforts, or they didn't believe the evidence he put on as to intent to expand around the United States, that he had abandoned the right to do so, basically.
Right, basically, yeah. Goods are much more difficult. I mean, there's no doubt about it. In terms of, you can ship into every state. You're basically doing business in every state. And if people in a state can get something, then you've got a nationwide business of selling goods everywhere, it seems to me.
Well, I tend to agree with you, and but I haven't seen anything legally that kind of really decides that.
The cases usually dwell on the technicalities of doing business in that state. Do you have a physical, trying to serve the simple part of it, serving a lawsuit, and getting jurisdiction, whether or not the person had an active website or a passive website. But if they have an active website where you can actually go in and there's a shopping cart and you can give your credit card, you would like to think they're doing business in every state, whether they have a physical presence there or not. I mean, there's so many issues that happen. So taxing, for example. I mean, all the various sales taxes was just finally getting sorted out. That when a California company, your Oregon company sells
to me in California,
should you pay California? Why shouldn't you pay California sales tax? I mean, and it's finally getting sorted out now. So it's an emerging area. You would have thought there'd be better law on this, but I think the overall lesson is, I think you have to be prudent and assume that just because somebody else is in some other state, you can get away with, if you will, selling the same goods under the same mark. I think the lesson is you should always opt to come up with your own unique mark.
Yeah, and register it.
And file to register it, absolutely.
Yeah, and I think it leads to one other issue that's very common, speaking of which, is along these lines with the internet. You mentioned the word active website versus a passive website. And as a practical matter, I've run into that a lot. And it is getting better as the internet seems to develop and people are more aware. But particularly the first 10 years of the internet, it was a constant challenge because many people don't have, there's many businesses now who do not have a physical location at all.
Right.
They're strictly an internet
Sure.
business,
Uh,
and they sell only by internet.
Mhm.
So then the question becomes, what constitutes the actual proper use that qualifies for a federal trademark when you're just on the internet? So it goes to this issue of an active versus passive website.
Sure.
Um,
Well, you get a lot of people who just sell through an intermediary like eBay or Amazon, and have even less of a business, so to speak. I mean, they let Amazon do all the selling and the fulfillment and all the rest. But that should qualify as use as well. I mean, the mark's being used to identify the goods. People are buying the goods because they identify them by that name, and the goods come with a label on with that name. It certainly should qualify as use, even if you don't have any physical. You could just be sitting in your living room in your pajamas and have a manufacturer subcontract makes it for you, and then he delivers it to a fulfillment house, and then Amazon does all the work for you, and you get a check. I mean, you're in business under that trademark if that product bears the trademark. So things have absolutely changed. You're right. The days of belching smokestacks as being the only way to make products are obviously long gone.
Well, and I think just to follow up a little bit on that active versus passive, because where I see it comes up, I mean, a great example is services. You know, if I'm a lawyer, I don't actually render services on the internet.
Right.
I may have a law firm website, and I'm sure your firm does as well. Most
Sure.
professionals do these days. But that is kind of a classic example of what I call a passive website, because it's really like advertising for your business. You're not
Right.
actually rendering the services at the site.
Right.
So that's an example of a passive website. Whereas I think when we're using the term active, it's that you can actually transact a transaction and buy something,
Right.
and there are examples of services where I think you probably on the internet as well,
Mhm.
of some sort.
Well, I mean, and service marks are easier in some respects to protect and register because, I mean, Google is running a browsing service. They may not be charging for it, but they certainly have a trademark for browsing services. And they get their money in different ways, but I mean, it's certainly a service. I mean, and a lot of services certainly took place over the internet, and you can. The offering of the services will qualify
As a registration.
to support your registration.
Exactly. And when I said the advertising, I meant it's advertising, but
Yeah.
for purposes if you wanted to get a trademark, let's say, for example, an active website where someone may have a picture of their product.
Mhm.
Say it's a hard good. There's
Right.
a picture of the product on the website, and they describe it with great detail, but you can't purchase it on the internet. One of the more popular ways to register a trademark on the internet is for an online store, an online retail store, right?
Sure.
So in order to qualify for the online retail store, you actually have to have that shopping cart element or a toll-free number where you can
Sure. No, exactly.
you prove the connection between the picture of the goods and the ability to access or actually consummate a transaction.
Right. No, exactly. And then again, the shipment. The goods should actually have the label inside or a hang tag or whatever they may be, that specifically has the mark on it as well.
So that would be
Yeah.
the category of whatever the goods are in themselves.
Sure,
Yeah.
sure, exactly. And actually, that circling all the way back to the Keep Calm thing. I mean, that's an interesting thing where a lot of people think they can just slap something on a T-shirt or on a mug, and that's trademark use, and it's really not. It's what we call ornamental use. You actually have to have. You may have a T-shirt that says "Keep Calm and Carry On," but it's got to be on the label as well. You've got to have a Keep Calm brand, if you will. And it's a technical sort of thing, but people don't understand that, and that's why we need trademark lawyers. There you go, so we can explain that to them.
Well, the ornamental use, it's interesting you bring that up because I remember many years ago when I started out that I did a lot of work in the music entertainment field, and it's quite common for most entertainers to have a merchandise
Sure.
program. That's where they make a lot of their money if they're successful. T-shirts, caps, jackets, shirts. And they don't normally put a label inside the shirt. They buy a shirt from Hanes or whoever, and then they put their band logo or group name across the front of the T-shirt.
Right.
Is that an example of what you're talking about?
Right, exactly. But there they have an exception
Okay.
because they already have a trademark for entertainment services for Motley Crue or Led Zeppelin or the Rolling Stones or whatever it might be. And so that's their primary trademark, which is the name of their band or their group for entertainment services. So when they do these ancillary items, these licensed items, that usage, even though it's just on the front of the shirt, let's say, or the hat, it comes under an exception for secondary uses, secondary source uses, they call them. So because that's merely buttressing and the primary and then the secondary, the primary being the entertainment services, the secondary being the, so that's an exception to the rule of needing a tag.
A tag,
or a
okay.
label, whatever.
I'd like to thank you for joining me today, Bill. Your information is wonderful. It's always a pleasure to speak with you, and you're welcome back anytime.
Great, it was a lot of fun. That's helpful. Thank you.